All right, good morning, everybody. Today is June 25th, 2024, 9:33 a.m. I am Commission Chair Michelle Espinoza, and I'm calling the meeting to order. May we have roll call?
Michelle Espinoza,
Here.
Erica Doyle,
Here.
Renee Lind,
Here.
Autumn Rubal.
Here.
You have a quorum.
Wonderful. At this time, I would like us to go into executive session. So I'm going to read the prompt here for that. This is Commission Chair Michelle Espinoza. This is a real estate commission meeting on June 25th, 2024, and the time is now 9:34 a.m. I move that the commission enter into executive session pursuant to Colorado Revised Statute Section 24-6-4023A2 for the following purpose: to confer with counsel to receive legal advice on specific legal questions regarding the forms change proposed. Specifically, the commission would like advice from counsel regarding legal basis for the proposed changes and any impacts the NAR commission may have on the proposed forms. Is there a second?
Second.
You? All those in favor?
Aye.
Aye.
Aye. Any opposed? There are 4 votes in favor of executive session. We will now enter into executive session. For our newbies, please make sure your video is stopped and you're muted before you enter into the other meeting.
Can I get a sound check?
We can hear you.
Yay. Okay, thank you.
All right, I'm so sorry. Can you hear me?
Yes.
Okay. Whole thing froze up. That's not good. Okay. All right. We are now on to the non-rulemaking hearing commission approved forms. Marcia, would you like to give us an overview?
So commissioners, before I go into the proposed changes, I wanted, because we've got a couple new commissioners, I wanted to explain the forms process just really briefly. So what it amounts to is, on a regular basis, we receive recommendations about or suggestions on how to change the forms. We maintain a global list of form suggestions, and then towards the end of each calendar year, the forms committee will vet those suggestions, and then in December we present forms change suggestions to the real estate commission and seek the commission's guidance at that time on what they would like the forms committee to work on in the upcoming year. With this particular year, we had over 100 suggestions on modifications to make to the contract to buy and sell. The real estate commission authorized the forms committee to move forward and make those changes to the contract to buy and sell. So that was going to be the primary form of focus for this year. And then the legislative session can always cause us to move things out of their 3-year cycle as necessary. Fortunately, we didn't have any legislation this year that necessitated any forms changes. But what did crop up this year was a proposed NAR settlement. And one of the things that I want to explain to you guys is the settlement is not binding on the real estate commission. This proposed NAR settlement applies to realtors and the brokers that use realtor-owned MLSs. The real estate commission licenses approximately 51,000 real estate brokers in the state. The realtors make up only a portion of our licensees. The real estate commission is charged with regulating real estate brokers and ensuring consumers are protected. The commission approved forms are promulgated for licensed real estate brokers to use in their representation of consumers. The purpose of the forms is not to enforce compliance with association or MLS rules. So with that in mind, I'm going to move into your first form for your consideration. This is the exclusive right to buy contract. So changes made to this form include clarifying the language that compensation charged by brokerage firms is not set by law and is fully negotiable. References to broker commissions has been changed to compensation throughout the contract. Section 7, the brokerage firm cannot accept additional compensation, incentives, or bonuses without the buyer's written approval. 7.3.1 authorizes the broker to seek payment from the seller or the seller's brokerage firm. The broker must disclose in writing prior to the buyer entering into a contract with the seller any portion of the broker's compensation that the broker must pay. 7.3.2, buyer must pay compensation. This requires the buyer to agree in writing to any additional compensation, incentives, or bonuses that would be received by the buyer's broker. If no box is checked, 7.3.1 is the default. And the provision that is currently in the listing contract that the buyer is not obligated to pay any compensation has been removed. Those are the proposed changes to the exclusive right to buy contract. Do you want to take these one by one, and that way you can ask questions on each of them and vote to adopt, and then we can move on to the next one? Or do you want me to do all of the proposed changes at one time?
I think maybe going one by one, and just for the benefit of the new commissioners as well. And I realized because of my technical difficulties, I missed the whole beginning part of our script. So if I need to do that, I can certainly go back over that. I apologize, Marcia.
Do you want to go ahead and just get it on the record?
Yep, absolutely. And then we can, unless the other commissioners have a question, then I think we should do them one by one. Just because I think there are some questions that are going to come up. So we're not confusing ourselves. So I'm going to back up a little bit. The Colorado Real Estate Commission has the authority to promulgate real estate forms for current use by real estate brokers pursuant to section 12.10, 12-10-403 CRS. These forms are referred to as commission approved forms. The purpose of this hearing is to hear oral testimony and accept written submissions relating to the following commission approved forms: executive right to buy listing contract, executive right to sell listing contract, brokerage disclosure to buyer, definition of working relationships, contract to buy and sell real estate. In addition to my fellow commissioners, here with me today are Director Waters, Deputy Director Turner, Senior Advisor Phipps, Board Liaison Doreen Archuleta from the Division of Real Estate, Gina Simonson, and Arena, I'm going to mess up your name, I'm so sorry, Grown from the Attorney General's Office, and Kent Levine and Damian Cox from the Forms Committee. The public record will consist of all testimony and any written information submitted within the allowable time frame. In addition to the public comments today, the Commission will review any written materials to make the final decision on the proposed new and modified forms. The public record will close at the end of this meeting. And thank you, Director Waters, for explaining the proposed modified forms.
Chair, I'm good. This is Gina Simonson from the AG's office. I'm just going to interject really quickly for the record that Irina Grony is not here today. There's just me. And when you introduced the forms, you defined the exclusive right to buy listing contract as the executive right, as well as the exclusive right to sell listing contract as the executive right to sell listing contract. I just want the record to be clear that it's the exclusive right to buy listing contract form and the exclusive right to sell listing contract form. And I'm sure that was just a quick misread, and I just wanted to get that for the rulemaking record.
Great, thank you. Do we want to take testimony at the beginning for all changes from the public? Marcia, do you think that's best, or to do it during each one?
It might be a little cleaner if you take them specific to each form. So if somebody has comments about the exclusive right to buy, now would be a good time to handle those.
Okay, perfect. If anybody has that testimony, please raise your hand so that Eric can see you.
Madam Chair, I do not see any hands raised.
All right, commissioners, with what was explained on this form, are there any questions regarding the proposed changes?
Nope, I think the changes look good. Are we voting in them one at a time? Each form one at a time?
I think that would be best being that we have some questions on the other forms. That way there's no
Okay.
confusion on what we're referring to.
And
Okay.
commissioners, I believe the AG had some proposed language about 7.3.1 for this,
That
to make it
was
more
on,
clear.
wasn't that the exclusive? Let's see. 7 point.
Do you want me to read the proposed language?
Yes, please.
So for 7.3.1, the proposal was that the language, the last sentence say, buyers obligated to pay any portion of the success fee which is not paid by the listing brokerage firm or seller, but only if broker discloses to buyer the amount buyer must pay in writing and prior to buyer entering into a contract with the seller. That would replace the sentence that says buyer is obligated to pay any portion of the brokerage firm's success fee which is not paid by the seller's brokerage firm or seller provided broker discloses to buyer in writing prior to buyer entering into a contract with the seller the amount buyer must pay.
Yeah, I think the new verbiage is much clearer, and I would move that we approve this form with changing to the new verbiage.
All right, do we have a second? Great, thank you. 7.3.1. Any further discussion? That language for 7.3.1 is approved.
Could I ask that the Attorney General send me that language so that I can insert it into the form?
I'll send it to you after this meeting.
Oh, thank you.
All right. Any other discussions regarding changes to this form? All right, so I think then we need a motion, correct, to approve the form as a whole. Is that correct, Marcia, with that one change?
Yes.
All right.
So I motion to approve the form with the change for 7.3.1.
We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes for the changes to the exclusive right to buy listing contract with the changes to 7.3.1.
So commissioners, the next form up for your consideration is the exclusive right to sell contract. The proposed changes to this form include clarifying language that compensation charged by the brokerage firms is not set by law and is fully negotiable. References to broker commissions has been changed to compensation throughout the contract. 7.1.1 includes new language about compensation agreements between brokerage firms and about the seller compensating the buyer's broker. 7.1.2 lease compensation includes language about the listing firm compensating the tenant's brokerage firm. 9.1.1 includes a sentence that the outside brokerage firm compensation will not be submitted to any MLS. This is a change that the Attorney General's office is recommending that you do not accept. 11.5 seller concessions has been added to the price and terms section. This is another change that the Attorney General's office is recommending that you do not accept. And then section 30 includes new language about the survival of the contract following the death of the seller. This change was not vetted through the Forms Committee's process, is not to the benefit of the consumer. We ask that you do not adopt this change, and the Attorney General's office is also asking that you don't adopt the change. And those are all of the changes for this form.
And then we would like new verbiage for 7.1.1.1 to be if buyer's brokerage firm 1 procures a buyer And 2, the transaction results in a closing of the sale of the property to such buyer. Seller's brokerage firm may enter into a compensation agreement with buyer's brokerage firm to contribute from the sale compensation an amount of blank percent of the gross purchase price or blank dollar amount in US dollars to buyer's brokerage firm. This language is just clarifying what was written, cleaning it up a little. And then for 7.1.1.2, the verbiage would like to change to, if seller agrees to pay buyer's brokerage firm pursuant to the contract between buyer and seller, seller's compensation to seller's brokerage firm shall be reduced by that amount not to exceed the buyer brokerage firm compensation set forth in 7.1.1.1.
Okay. Great. At this time, if there's any testimony, please raise your hand and let, so Eric can see you. I do want to remind everybody that if you are giving testimony, you are limited to 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you are representing, if applicable. Please limit your testimony to only the proposed new and modified form that we're discussing, and do not duplicate testimony. Should the commission or any of its representatives have a question regarding your testimony, we will ask when you have finished your testimony. So please raise your hand if you want to give any testimony at this time on this form.
Madam Chair, I do not see any hands.
Okay, I do have several other things on this form to go over.
Okay.
The first one being the other form was mandatory 824. This one says 125. I believe that should be corrected to 824 as well.
Yeah, I have that same question. Can we get some clarification on why some forms are mandatory in August and some say January, or if that's just a typo?
That's a typo. They should all say August of 2024.
Okay. And then on number 7, it's a compensation to brokerage firm. It says compensation to cooperative broker. I believe that should say compensation to buyer broker.
Mhm.
I don't know if I should talk or wait to be recognized.
Yes, go ahead, Damien.
I think that depends on what I didn't follow all the language that was thrown in 7.1.1.1 when Commissioner Line was reading it. In the past, it's always been a cooperative broker. I'm happy to change it to a buyer broker. If that's, and it probably should be compensation to buyer brokerage firm instead, if we want to get technical, but I'm happy to do whatever you want on that.
Okay, let's change it to buyer brokerage firm so it is consistent. Okay, then we had the new verbiage that I read there. And then we had the section 9.1.1 where we want to take that additional sentence out.
My question for the Forms Committee is why did we feel like as a committee that was relevant, being that an outside brokerage firm is not a party to this contract?
It's the outside brokerage firm's compensation, which is the co-op commission, which is now prohibited under the MLS. And we thought it was important to put in here that the seller understand that that's no longer going to be a part of the MLS as a disclosure that it's not to be included. That was the reason we added it. I mean, if you guys want to take it out, that's fine. But it was more for the seller to make sure that they understand the rule change as well, that it's no longer part of the MLS.
Yeah,
I think-
I don't think that needs to be part of the contract, which I believe.
Yeah, we
Hey,
should
correct.
take that out. And then we had 11.5, where we would like to remove 11.5 having to do with seller concession. We don't believe that should be in the contract. And then number 30, as was referenced before, we would like to remove that additional sentence in number 30 that was
Yeah,
recommended. We want to remove that.
and my apologies, that was my fault including that. It wasn't intentional. Kent and I were discussing another legal matter about making a change to this, and I used this version and had it meant to talk to Director Waters as well as the Forms Committee and everything, and it didn't happen. So my apologies, that should have never been in there to begin with. So I'm sorry that I did that.
It's okay, so we'll take that out. And then those were the changes I had. Anyone else have changes for the listing exclusive right to sell listing contract?
I think you've covered mine. We have Erica or Autumn, do you have any questions or comments regarding the changes to this form?
No, that covers that. Can you reread that 7.1.1.1 again for me?
Yes.
Thank you.
It is if buyer's brokerage firm one procures a buyer, and two, the transaction results in a closing of the sale of the property to such buyer, seller's brokerage firm may enter into a compensation agreement with buyer's brokerage firm to contribute from the sale compensation of an amount, just an amount of blank percent of the gross purchase price or blank dollar amount in US dollars to buyer's brokerage firm.
Thank you. I wanted to make sure I had sellers in the same spot I wrote it in. Thank you.
Yes. And then that would be the same thing. Do you need me to do the 7.1.1.2?
I believe I have it, but why don't you go ahead and do that one more time for us?
Okay. If seller agrees to pay the buyer's brokerage firm pursuant to the contract between buyer and seller, seller's compensation to seller's brokerage firm shall be reduced by that amount not to exceed the buyer's brokerage firm compensation set forth in 7.1.1.1.
Yes, thank you.
All right, commissioners, any other discussion on proposed changes or the changes that have been brought before you? All right, hearing none, may I get a motion to approve the proposed changes given today?
Okay. I motion to approve the exclusive right to sell listing contract with the changes we have discussed with verbiage and removal.
Second.
All right. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes with those changes.
So commissioners, the next form up is the brokerage disclosure to buyer definition of working relationships. With this form, the proposed changes, there's a new section added at the bottom of the form titled Buyer's Brokers Compensation Agreement. This new language was added to the form to address instances when a buyer is working with when a broker is working with the buyer as a transaction broker and does not have a signed listing agreement. The language authorizes the broker to seek compensation from the listing brokerage firm or the seller. The language also clarifies that the buyer is obligated to pay any portion of the compensation owed to the broker that is not paid by the listing brokerage firm or the seller, as long as the amount is disclosed in writing to the buyer prior to executing the contract with the seller. The compensation agreement also clarifies that the buyer must authorize any additional compensation, incentive, or bonus to be paid to the buyer's broker.
Does this form, and maybe I missed it, but is there a time frame in which this needs to be signed?
Well, this form is this form is used before any confidential information is gathered. And this is one of those forms that's currently, it doesn't have the compensation language, obviously, but people can refuse to sign it, and we expect that the broker just refuse to sign and date it, which could still happen even with the compensation language.
So I don't understand why the whole section that was added is necessary. I don't think it's necessary at all. If you're gonna get into this, you might as well just do the exclusive right to buy listing contract. We don't need this. It is not, it's not explaining enough to the consumer. I don't think they're gonna understand, and I think I don't think this page is reasonable. And we're not required to do this either by Colorado law. So I don't know why we're adding this.
Can we get someone from the forms committee to maybe enlighten us on the thought process behind this form?
I'd be happy to. So there's a couple different reasons for this, and as Director Waters said, the settlement agreement does not apply to the Division of Real Estate or the Commission. However, you do have, my guess is probably anywhere from 2/3 to 3/4 of your active licensees that are either members of an MLS or are realtors that are required under the NAR settlement to, and I know that this is, they're under the NAR settlement, they're supposed to do an agreement with buyers prior to them showing property. Now, as Director Waters has stated in many of her appearances, she does not believe that that is Colorado law, which I happen to agree with her. But nonetheless, that is something that's come out of the NAR settlement. But more importantly, with the offer of compensation going away, buyer brokers do not have a mechanism to get paid under the circumstances where they decide to be TB using that form. So if they just do the default of TB, my guess is that they'll end up, there is no compensation or way for them to get compensation in the transaction. And once they become a TB, they do have duties that they are required to give to the buyer as far as writing contracts and negotiations and those things, but there's no mechanism under your rules for them to actually put compensation into the contract, as the annual commission update course has been teaching for years. In order to put commissions in the contract, you must have an obligation to pay. So that creates an issue there, and the fact that you got a bunch of brokers that won't have that. And frankly, while in the Front Range, I think a lot of brokers have been using the buyer listing contract. When you start to get to the resort communities of Vail, Aspen, Telluride, and some of these others, it becomes a bigger issue as people that come in from out of town want to go look at properties for a couple properties on the weekend or something, and they're not willing to sign a full-blown exclusive contract. What this does is it says, hey, if I introduce you to the property, then you will pay me this commission, and it's not a full-blown commitment by the buyer to the broker for 6 months, 3 months, 2 months, whatever you want to call it. It's more of a dumbed down, lazier, I won't say lazier, but a smaller version of getting the compensation out on the table for the buyer and the buyer broker.
You can do the same thing with the exclusive right to buy listing contract. That contract can be used for one day, it can be used for one property. It could be, so it is serving the same purpose. I don't think we need this additional form. We might as well use the exclusive right to buy listing contract and be explaining to them how things are being done, what your services are, etc. This doesn't really explain anything to them.
Well, I do believe that if you look at the first 2 pages, the broker disclosure to buyer, it does spell out the relationships, the different relationships and what they have in them. It also talks about how they will be representing them in the check boxes above. So this actually does and has been for years the purpose of disclosing the working relationship to people when they aren't signing contracts. which is still a form that would be used regardless of the compensation agreement. If somebody's going to go out and show property, to Director Waters' point, in Colorado, they can still do it under this broker's disclosure to buyer. But the problem becomes when they say, great, we found a property, we want you to write a contract. The broker cannot get compensation under the current rules. The current rules state that they have to have an agreement to pay commission. And this alone does not create that obligation, which means, I mean, I'm not disagreeing with you, Commissioner Lynd, as far as the fact that they could use the other form, but there are a lot of mountain communities that strictly use the brokerage disclosure to buyer and have done so for years. And pivoting is going to be not only difficult for them, but it's going to be difficult for their clients who don't want to sign exclusive agreements, even if it is for one day or one property or anything else.
Well, the other concern I saw is it says it's a transaction broker. If you are showing a property, if you are representing the seller, you're the selling agent. And you can't say you're going to be a transaction broker without changing that relationship with the seller, getting permission to do that. So I see that there's going to be a conflict between a relationship with the seller, and then you're telling this person you're a transaction broker. You may not be able to be a transaction broker.
Well, if you look again at the second page of the form, there's a checkbox. And the reason we did that is because if they are exclusively a customer, there shouldn't be a compensation agreement because the seller has already agreed to pay that person whatever their agreement is through the seller listing contract. But the checkboxes in this form spell out what is the relationship between the broker and the buyer that is coming in. And you can see there is customer or transaction broker because it's going to be one or the other. And we didn't want this compensation agreement to, as you're saying, to apply to customers because that compensation is already taken care of through the seller's listing contract. It really is only for when they're disclosing that they are when they are working with the buyer as a transaction broker.
One of the questions that I have is, on the BD 24, it says this brokerage disclosure to buyer is not a contract, but then page 3 will be an agreement.
That's true.
For compensation. And so I think, that's going to be difficult to discuss with them.
And I don't anticipate that, buyers do not have to sign the commission agreement and then or the compensation agreement, and then brokers will have to decide if they want to move forward working with that buyer without a compensation agreement, in which they may not receive any compensation if they're unable to enter into a buyer listing contract later. But you're absolutely right, Commissioner Doyle, in the fact that this could be zeros in it. It could be they don't sign it. It could be, but it feels like that the brokers and the buyer should at least have this option. So if they don't want to change to a buyer listing contract or something later, there is compensation to the broker for the work that they're doing. And then they'll have to make a business decision as to whether or not they're entering into them or not.
I can see the need for it 100%. That being said, that it's attached to the BD 24 and there clearly is an agreement on one page and then the other one is not an agreement, that seems problematic to me. Can we have it?
I mean, it really is
document.
Well, we've had forms before that have included 2 documents in one form, and that's what really this is. And I think Commissioner Waters has found that in her team's investigations that a lot of times the brokers are not using this form correctly or when they should be using it. And so the concept was that putting the 2 together might make the brokerage disclosure to buyer used more often. I think another concern would be is if you split the forms, people are going to enter into compensation agreements, but then they don't disclose working relationships, which is really kind of an important part of that compensation agreement, is for people to understand what the broker's relationship is with them.
I agree.
So commissioners, this is a painfully non-complied with form as far as just the brokerage disclosure to buyer is concerned. And the concept of merging the two, if you need to put somebody on notice about compensation, made sense to hopefully reinforce that they need to be doing the brokerage disclosure to the buyer. I'm not aware, though, of how, in the grand scheme of things, and I guess this is probably a question to wait and see what happens in the courts, that if you don't have a signed compensation agreement as a transaction broker for a buyer, that you're not going to get paid if you can demonstrate that you performed all the duties. I don't see how the NAR settlement necessarily results in that type of end, but given
I think the claim would probably be a quantum merit claim, though, because there's nothing in writing that establishes the amount of compensation. I mean, maybe Kent can chime in on this, but my thought would be as if this is zero, then they'd be making a quantum merit claim that they did receive services, so they're entitled to something, but then it's a court action.
All right. I also agree with Commissioner Doyle. I think it's a good option to have for them. And yes, I definitely understand that they don't use this form. But I think with all of the questions floating around, and just maybe some anxiety of how they're going to get paid, I think having this as a tool, as a resource for them to be able to articulate this to their potential client, I think is good to have. So that's my 2 cents.
So they don't have to sign this form, just like they don't have to sign the other form, right?
no, they do
So
not.
if they
Correct.
don't have to sign it, why not have another form and just have the first form that we already have? If they have the option not to sign them, there's
Well, I think it goes more to mentality, probably, and attitude. I mean, if you're sitting down in front of a potential client, and you're trying to give them these pages and pages of a contract, right? Or this to at least get the ball rolling, I think that alleviates some of the nerves probably on both sides. But yes, it's not required, but I think it's a tool and a resource that they can use to get those conversations started. So
I guess I still have a problem because it says transaction broker. And if it's the house you have listed, like I said, if you're the buyer's broker, we're going back to that. How can, and someone walks in and wants to see the house, you can't just say, okay, I'm going to be a transaction broker because you haven't cleared that with the seller. You haven't changed the paperwork. You haven't done whatever. I don't know how we can say, okay, sign this, I'm your transaction broker, when you may not really be the transaction broker.
Are you talking about if you're the listing agent and
Yes.
the buyer? Okay, so if you're the listing agent, right, you've got
Yes.
your listing contract with that seller.
Right.
Are we saying we would just give the BD 24 to that buyer when they walk in, saying that we represent the seller? We don't have to give them this third page because we wouldn't have a compensation agreement with them. We're just getting paid by the seller.
And if you look, that's
You
the
may
reason
not be.
that's the reason there's a distinction between transaction broker and customer in the compensation agreement, is because if you check the box that they're a customer, then the other one doesn't apply because it only applies to people that are acting as transaction broker. It was trying to tie the relationship to the compensation agreement.
But then we're going back to, okay, the seller's paying everything. And this whole lawsuit thing, what if the seller says, no, I'm paying part of it? You've got to get the rest from the buyer.
Well, their agreement says what their agreement says. And if they're
Right, but
acting as their agent, if they're acting as their seller's agent, and they have agreed that they're going to get paid X amount of dollars under the seller listing contract, then that agreement is already in place. There is no, you got to go back to the buyer. It's whatever their agreement is that they're getting paid.
Okay, normally they're going to get paid from both sides.
But that's all contained within the seller listing contract as far as the compensation is X and we're offering Y to buyer brokerage firms out of the X. They aren't split in the listing contract. There's one total commission and a portion of that goes to the buyer brokerage firm if they include anything, which they could put 0 in, obviously. So I think it's all contained in the seller listing contract as to what the broker's compensation is, regardless of whether they're TB or customer.
So basically, is it the first line of this compensation agreement, Renee, that is,
Well, I don't like the transaction broker, but I also don't know if we need this form is the whole thing. I don't know why we need another form when we already have the exclusive right to buy listing contract. So, we're adding more instead of, okay, just use the other one. But yeah, I don't like the transaction broker thing. I think there's there's going to be an issue with that somewhere.
So you would be okay if on that first line, we took out as buyer's transaction broker, because the BD 24 up above would be giving them the disclosure as to how that person handing it to them is acting in the transaction. And so it would just say, in consideration of the services to be performed by buyer broker's brokerage firm will be paid fee equal to, and so forth. It just takes out as buyer's transaction broker.
If I may, I'm afraid that doing that would be inconsistent with the seller listing contract, because now you could have a customer paying compensation where it seems inappropriate if they have a listing contract with the seller that they're supposed to receive compensation for their duties to the seller. I respectfully think that the transaction broker has to be a limitation on this compensation agreement.
On the compensation agreement, yeah.
So Commissioner Lind, they could also, if it's the listing agent showing the property and doing the brokerage disclosure to the buyer, they could also strike through the compensation agreement to make it clear that it doesn't apply. And since we're on this topic of transaction brokers for buyers, this concept that you have to have a signed compensation agreement before you go show property, that's not Colorado law. And that is not something that we are going to ask the commission to direct the forms committee to do, because that's not consumer protective. They just want to see a house. They don't necessarily want to sign a contract with a broker just because they want to see a house. So this just kind of flags for them, if they're going to be working with this broker as a transaction broker, that the broker's going to expect payment in that instance. But if you've got a broker that's making the disclosure to the buyer and they don't have a relationship, they're not going to have a relationship with that buyer, they can strike through this compensation agreement to make it clear that it's not applicable.
So do we need this third page or not then?
Well, when you're dealing, I think it is necessary as far as putting a consumer on notice when they are working with a broker as a transaction broker, and then they don't want to sign a listing agreement as a buyer. They're allowed to do that. And at least it gives the buyer an opportunity to have a discussion with that transaction broker that's representing them about what the compensation is going to be, rather than having to go through a legal battle later on and having it turn out to be something that they wouldn't have agreed on.
So they could fill out the first 2 pages and refuse to do the third.
They could refuse to sign any of it.
Yeah.
all right, any more discussion? All right, I think let's just start with a motion for this form, for this disclosure.
I motion to approve the brokerage disclosure to buyer definitions of working relationships.
Thank you. Do we have a second?
I'll second.
Any further discussion? All those in favor? Oh, go ahead.
Sorry to interrupt, but I think the AG had some proposed language with this one as well. As far as compensation language was concerned, the recommendation was that the last sentence of the buyer's broker's compensation agreement and the brokerage disclosure say buyer is obligated to pay any portion of the success fee which is not paid by the listing brokerage firm or seller, but only if broker discloses to buyer the amount buyer must pay in writing and prior to buyer entering into a contract with the seller.
Yes, that lines up with the other ones that we did, I believe.
I'm good with that language. Autumn, are you still okay with that with your second?
I am.
Okay. All right. All those in favor?
Aye.
Aye.
Aye. Any opposed?
Aye.
Motion passes with 3 votes for aye.
Okay, commissioners, the last one is the big one. It's the contract to buy and sell. First, I'm going to go through the residential changes. So 2.5.4 has advisory language about home warranty programs. This is just being moved up in the contract. 2.5.5, encumbered inclusions, language is being added as to whether the buyer will assume the debt and obligations related to encumbered inclusions. This is also getting moved up in the contract. 2.5.8, leased items, the language is being added as to whether the buyer will assume the seller's debt and obligations related to the leased items. This is getting moved up in the contract. 2.5.9 is a new inclusion about solar power plans. It includes language as to whether the buyer will assume the seller's obligations under the solar power plan. 2.7.6 modifies the language to give the buyer the right to terminate the contract if the water rights are unsatisfactory. 4.5.3 includes a sentence that the cost the seller agrees to pay for the buyer with a VA or FHA loan does not include any compensation to be paid to the buyer's brokerage firm. 4.6 assumption, this includes a new sentence that the contract will terminate if the seller's lender does not provide written consent of the buyer's assumption of the loan by all parties and the closing company on or before closing. 5.1 adds assumption to this section title. 5.3 and 5.4 deletes language about the release of an existing loan. 5.5 is a new section for the buyer to represent whether the buyer will occupy the property as their principal residence. 8.9 has changed to indicate that the buyer has a right to terminate if mineral rights are unsatisfactory. 10.2, the last sentence is being modified that the property and the inclusions are being conveyed in as-is condition. 10.6.1.2 has language that was deleted and added to 2.5.5. 10.6.1.3 has language that was deleted and added to 2.5.8. 10.6.1.4 adds language about solar power plans to the due diligence documents. 10.6.1.5 adds language about septic permits being added to the due diligence documents. 10.6.2.4 creates an automatic extension if a due diligence document is not delivered on or by the due diligence deadline. 12.3 revises the language that the seller must provide the buyer with the ability to access the property. This is to include keys, access codes, and garage door openers. 5.3.3 deletes language about advance payment of association assessments. 15.7 clarifies the language about water transfer fees. 16.2 clarifies that the seller is responsible for paying all association assessments accrued prior to closing, and the buyer is responsible for paying all association assessments accrued after closing. 17, language was added about the post-closing occupancy agreement controlling about possession date and time. It deletes the representation language about the property being the principal residence of the buyer. It includes language about the buyer's ability to seek a claim against the seller for damages. 18.5 deletes the home warranty language that was moved to 2.5.4. 24 adds a sentence that any notice to terminate delivered after the applicable deadline is ineffective and does not terminate the contract. And 29 is a new provision that makes the buyer's brokerage firm's compensation negotiable within the body of the contract. And with the contract to buy and sell commercial, the proposed change to that is 10.6.4, which moves the language about an ADA evaluation into section 10.6.5.
Okay. Did we have any we did not have any proposed language change on this one, correct?
Correct.
Okay. So at this time, let's open it up to public testimony. Please raise your virtual hand if you have any testimony you would like to give.
Madam Chair, no hands raised except for Mr. Cox.
All right, Damien, what you got?
Just really quickly, I wanted to point out that this was another typo for the mandatory. It should have been 824 that you caught in the last one. I apologize, I missed that one too.
All right.
So I know the home warranty was in there previously, but it's been moved, so now it's been drawn to my attention. Why do we have a sentence about a home warranty in this contract?
So that was added a long time ago because it is a consumer protection issue as far as if sellers and buyers that get home warranties tend to have coverage for items that go wrong after closing, which is a benefit to the seller because they don't get sued over something that the buyer now claims was an adverse material defect. And for buyers, it's a protection because now they have insurance. That was the reasoning for it years ago when it was drawn in, was just to advise them that that is a possibility.
Okay. There are several sections that I believe should have dates in them, that should have the dates on our grid of dates. And they are 2.55, 2.58, 2.59, and 4.6.
Can you go through the dates that you're talking about? I'm not following.
Okay. Right now the verbiage has been changed in these that's basically say it's giving someone an out to a contract almost, right? That they can, if you don't get something before closing, and one of them actually says on closing. And some of these things I believe should have dates for consumer protection, that you needed the date that, like the solar, I need a date 2 weeks before closing that we have the solar plan done.
So the leased items, the solar power plan, the encumbered inclusions are all actually in due diligence where they are subject to dates and they have the provisions that allow the buyer to object as well as the resolution period. So putting it in two sections would mean they'd have rights under two different sections. It's kind of we struggle. I would love to have these all contained in one separate section, but I don't know how, we didn't know how to do it. And what we've done in the past is we had because inclusions is 2.5, we've included all the things that are part of those inclusions, whether it's leased items, solar power plants, the solar panels, if they're encumbered inclusions, etc., because that means they're part of the inclusions. When we moved these provisions up to the inclusions, it was to put it more in front of people as far as whether or not they were taking over those obligations. But as far as their rights to object to those and resolution, they still are all contained in paragraph 10. And if you look at paragraph, so 10.6.1.3 talks about encumbered inclusions, and they have a right under due diligence delivery they have to be provided by the due diligence documents delivery deadline. Solar panels is in 10.6.1.4. We have the leased items is in 10.6.1.2. So they all do have rights as far as objecting and terminating, but the delivery of those documents for the buyer to review is part of due diligence because we're talking about due diligence documents at that point. So that's why it's the right to object and resolve is still in 10, just like it's been before. We just moved up whether the buyer was assuming those obligations or not to paragraph 2.
Okay, so you could object to something, but you haven't gotten it yet?
No, the rights, if you look at 10.6.1.2 and you look at 1.3 and 1.4 and 1.5 for that matter, or 1.4, I guess 1.5 is different because it's health department, but they all say that, well, actually, if you look at 10.6.1, which is all of these documents, it says seller agrees to deliver copies of the following documents and information pertaining to the property and leased items to buyer on before due diligence document delivery deadline. And then you have their rights under 10.6.2 for those due diligence documents to terminate or object. And then you have resolution under 10.6.2.3. And the reason we added 10.6.2.4 was that if somebody hadn't provided them, we wanted to extend the right to object out further. So that's why 10.6.2.4 was added, is that we realized in past versions of this, we did not have an automatic extension, just like we do in title documents. When the seller doesn't provide stuff on time, the buyer should get an extension of their time to review and object. So all of those are contained in due diligence because we are talking about documents that are to be delivered to the buyer. But if you go up to paragraph 2, that's just talking about what is included in the sale and whether or not the buyer is going to assume the seller's obligations under those items.
Okay, but it's asking for written approval by lender before closing. Okay.
Right. Well, the reason that's in there about the lender approval is because we've had issues with the leased items, and that doesn't really fall under due diligence documents because it's the due diligence documents are the encumbrance, the whatever it is, or the lease or whatever it is that the buyer would have to review and object to under due diligence. If the lender doesn't approve it later, then the buyer should have an ability to get out of the contract because now they're not being approved to take over the lease or take over the encumbrance. But that is not something the buyer is reviewing and saying okay with. It's did you get the approval or not?
Okay, I guess my point is that as a buyer or a seller, I would want this approval prior because people have their bags packed. They're already in the moving truck. Somebody's left, somebody's moving in, and you get up to before closing. It doesn't specify day, time. Is it 1 minute before closing? You go, I don't have this. Contract is terminated. And
I understand the point, and I agree. The problem is this is third parties that we can't obligate in a contract to do something. And from what I understand, Tesla being the biggest one with the solar panel leases doesn't provide that until the day of closing. So if you put in here that it's to be provided beforehand, you're putting the buyer in a position of, are you terminating the agreement or are you taking a leap of faith that you're going to get it before closing? I'd rather the buyer have a right to walk away if they don't get it. But I mean, that's your guys' discretion as far as how you feel best protects the consumers.
It's also not protecting the seller though, because you get all the way to closing and something doesn't go through. And so now all of a sudden the seller, okay, if you want to close in 1 minute, you're going to have to fork out, say, all the money to buy the solar equipment or the deal's dead. And they're already packed and moved somewhere. I don't know. I don't like that it's, you don't get this till before closing or on closing.
I think part of the issue on that though is it's the seller's solar system and it's the seller's company that has not, come to the table. In my experience, it's always been like pulling teeth trying to get that information so that we even get it by closing is helpful, but it's the buyer that's waiting for that information from the seller's chosen company in most cases.
I don't know. My comment was on some of these things, I thought it should be done further ahead of time rather than waiting till the most stressful time there is, which is at closing or right before closing to see if something's going to work.
And you're not wrong there. I totally understand that. It's just sometimes on those third parties is the major issue at play.
You guys, I'm very sorry to interrupt this dialogue. I have a hard stop at 11. I wasn't anticipating the meeting run past 11. but I never saw an end time either. I can certainly call in on my phone, but you will not be able to see me or my video.
Okay, thank you. I think we're almost done. I just want to ask one question on this, specifically the buyer will or will not assume the debt and obligations on the encumbered inclusions subject to buyer's review under 10.6. And buyers receive written approval by such lender before closing. So the lender has to provide written proof that it's okay for the buyer to take on this debt. Is that what we're saying? And until they have the financing from these, the lender can't make a decision?
So what this is meant to do is usually the listing says, hey, we have encumbered solar panels that we want the buyer to take over. So they write the contract based on whether the buyer is or is not going to assume the debt. And what we found is that when it was down lower in the contract, it just got missed. We thought this would help people see it when they're talking about those encumbered inclusions. And so if they check the box will, it's still subject to them reviewing all of those encumbered inclusion documents, all the loan documents under the due diligence document delivery deadline. And then it also says it's contingent upon them receiving that lender approval. So if they don't receive the lender approval, then the contract would terminate, giving the buyer protection that if they're not approved to take over the encumbrance, then they're protected. But likewise, Renee, the seller would be protected too, because if the buyer can't take it over and they sell it to them, that means the seller is still going to be obligated under that encumbrance. So I agree with Commissioner Doyle that I wish that we could get it a week before closing, but that's not practical. It just doesn't happen.
Man, I see what Renee's concern is. Like, if you're sitting there the day of closing and you're still waiting for that, oh, that's just so nerve-wracking. But also that you have to wait for that. That's just sounds like it's going to be a huge education piece for the broker to their client on.
I actually think that's the way it's been working now. It just hasn't been an out in the contract, which has created the conflict, in several different directions, because you have buyers that are like, no, I want to still buy it. I'm sorry that they didn't approve me, but seller, I'm still buying the property and you get to keep the inclusion, or you get to keep the debt, or vice versa, where the sellers are like, yeah, we want to sell. I don't care that you weren't approved. You're still buying the property. It's just, I don't know there's no other way to deal with it because you can't make a third party obligated under the contract. So.
All right.
But this is what you're referencing. This goes with your change at 10.6.2.4.
Yeah, so paragraph 10 has all of these are in there. If you look, you see encumbered inclusions, leased items, solar power plant are all there. That says the seller has to deliver those documents so that the buyer has an opportunity to review and object to them. And then we added the automatic extension because that wasn't in there. So if the seller doesn't deliver them timely, they still have additional time to review and object.
Although this, again, it says it's extended to the earlier of closing. So you could not have the document, be sitting at the closing table, and now you have the document and go, oh, I can't do this.
Except this gives them the right to object, which includes terminate up until that time. And yes, it could be that long, but if the seller didn't deliver the documents on time, then that's the price the seller pays because we got this extension. It's the same language as in the title work, whether it's off record title or record title, that allows an extension if the seller doesn't provide it timely. It's the same concept.
Okay.
All right. Any other discussion?
The only other thing I had was on the commercial contract, all the dates at the bottom, that lower heading at the bottom, those all need to be changed too. And then this contract, the commercial one says 125. Is that one supposed to be 824?
Yes.
So then we need to change all the dates at the bottom as well.
Okay. And I'm sorry, can you tell me what you're referring to, the dates? I just pulled up the
On
CB,
the, yeah, right now it says 623.
Okay, yeah, my apologies. Yes.
So we need to change all those on every page, even though we're not changing much with that contract.
Well, it'll get, if you guys vote to approve the residential version, we'd ask that you also approve conforming changes from the residential over into the commercial. So those changes that we're talking about in the residential would also be taken over to the commercial. It's just commercial has the additional changes because obviously environmental and ADA doesn't apply to commercial or doesn't apply to residential.
all right. Any other discussion? All right, can we get a motion?
Motion to approve contract to buy and sell real estate for residential and commercial with the changes noted.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? And I don't think Autumn was able to rejoin, so she is absent from this vote. All right, I think,
So commissioners, we have one last thing to request of you that we do with every forum's non-rulemaking hearing, is that for you to grant the division a delegation of authority to basically fix any typographical errors or non-substantive issues with the forums as we go through and finalize these.
all right, can someone make that motion?
I move that we approve to do those. To do that. Give authorization.
Okay, we have a second.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes. All right. Thank you, everybody. I think that ends our meeting for today. Sorry, it was a little rocky, but it happens. So I appreciate everybody's hard work. The Forums Committee, thank you so much for your due diligence and all the effort you put into that. We really appreciate that. And everybody have a great rest of your day.
Thank you, commissioners.
Thanks.
Commissioners.
Take care.